So the preliminary reference proceeding is an interplay between national courts and Luxembourg and Kirchberg. As we know, these slides, the presentation that are going to be made available to you, they contain a direct link to the sources, the most important sources. I listed them here. It's not only the treaty about the functioning of the European Union, the treaty about the European Union, not only the rules of procedures. I would recommend to start with the practice rules for the implementation of rules for procedure, because they are really practical and practice oriented. And then there are some referral recommendations. As we know, it's not up to us to decide whether we can go to Luxembourg, not us as defense attorneys, but it depends on the court. And those referral recommendations are addressed to the court. In my experience, at least Italian national judges, they are not really aware about how that works. So I would definitely recommend to draft a referral for the court using the even the methodology which is recommended by the court. So just drafting for them in what I am doing every time that I think that there is a question about the interpretation of EU law in the national main proceeding, I attach a plea as if the court, so ready for the court to submit it. So just following, so making the life for the court much more easy. Of course, we know that the referral has to the object of the referral is the interpretation of EU law, not the interpretation of national law, of course. And there is a presumption of relevance in the national proceedings. So the Court of Justice, other than other Supreme Courts or constitutional courts, they are not going to question the relevance of the question posed, because that's led to the national court. I specify that because a couple of months ago, a colleague stepped up to me saying, okay, but the national court would like to know, because they don't want to be blamed that the question could not be relevant, but this is not a risk that it's going to be highlighted by the Court of Justice. The EU law has to, which interpretation is questioned, has to be applied in the main proceeding. The main proceeding is going to be suspended. It takes from between 1 and 2.5 years, depending on which procedure is going to be followed, until the Court of Justice delivers the decision, and we are going to come back to that, of course. And the Court of Justice will just give the interpretation of the requested EU law, meaning that it's then up to the national court to draw its conclusions regarding the how to handle in the national case the interpretation given by the Court of Justice. Of course, bear in mind that it's going to be translated in the 20+ official languages of the European Union, at least if it's not a PPU proceeding, so an expedited proceeding. And this means that the simpler it is, the better it will work in the interplay with the governments and with the Commission, which are the other parties of the possible parties of the proceeding, beside from the Advocate General, but we will come back to that as well. What I'm going to present right now is, I am a criminal defense attorney, so of course, regarding the preliminary rulings to Luxembourg, the fundamental rights defense or the rights defense is the focus that I have always in mind. And so please be kind with me and allow me to explain just in a couple of slides what exactly we are talking about when we are talking about the fundamental rights defense. As you know, after 1999, in the space of freedom, security, and justice, the whole system is based on the mutual recognition among member states. But if we think about that, mutual recognition requires trust, and the trust is based on the certainty that in every member states, the rights are equally protected and recognized, so recognized and protected. Of course, we're speaking about the rights of the individual in the criminal procedure regarding it also as it is called in Article 82 of the Treaty of the Functioning of the European Union, and we speak about fundamental rights as well. As the Court of Justice phrased it in the famous Durbanto case of 2019, which regarded the detention conditions after Aranyoso and Calderaro. It says that the principle of mutual trust between the member states and the principle of mutual recognition are in EU law of fundamental importance, and more specifically, the principle of mutual trust requires to consider all the other member states to be complying with EU law, and particularly with the fundamental rights recognized by EU law. This presumption is not absolute, as we learned, and because as the Italian constitution put it in the 1985 obiter dictum, that the international criminal law enforcement needs, so there's the need to cooperate in order to avoid impunity, as the Court of Justice puts it in its decisions, that this necessity of having a very strong collaboration between judicial authorities cannot prejudice or harm fundamental rights, and which are exactly, even if sometimes, even in these days, if I look what is happening, not only in Europe, but even in other very near states, at least of the Mediterranean, European Union should be or is based on fundamental rights. And we go to the Article 2 of the Treaty of the European Union, which states that the Union is founded on values of respect of human dignity, freedom, democracy, rule of law, and respect of human rights, but especially Article 6 of the Treaty of the European Union, which says that fundamental rights, as they are guaranteed by the European Convention for Human Rights, and as they result from the constitutional traditions common to the member states, shall constitute general principles of the Union law. So it wouldn't be completely new to us to compare as the source of these fundamental rights, not only the European Convention of Human Rights, but even their parallel rights as mentioned in the Charter. So life, the provision of torture, provision of forced labor, liberty, security, the fair trial, the private and family life, and so on. So the experience has shown that even if all member states are party to the European Convention of Human Rights, this doesn't mean that they provide a sufficient degree of trust in the criminal justice systems of other member states. So the European legislator tried to strengthen this degree of protection to the degree of trust. And remember the pyramid I showed earlier, so the chance to have the mutual recognition with the so-called EU procedural rights, which are of fundamental importance when it comes to the criminal trial. So we all know that there was the Swedish roadmap in the Stockholm program of 2009, in which a certain amount of procedural rights were drawn and were imagined. Then we had, with a little bit of delay, the realization of this Stockholm program. And as we know, we had the first transposition was the Directive 64/2010 about the right to interpretation and translation, because it has been recognized by the EU legislator that there cannot be a fair trial. So Article 6 or the equivalent of the Charter, the equivalent articles of the Charter, without the understanding of the charges and the chance to have an effective participation, things that you already know: the right to information, the access to a lawyer, children's safeguards, the presumption of innocence, and the right to be present at trial, and the legal aid directive as well. So the job seemed to be done, and no need for a preliminary reference should have been in mind of anybody. But as we know, the conventions, they protect not illusionary or theoretical rights, but rights that are practical and effective. And that we, especially we criminal defense attorney, we know that there is still a long way to go from theoretical rights to practical rights, so rights that are effectively protecting the individuals in the, I say, criminal procedure. And this is true in all the instrument of this mutual recognition, in the mutual recognition area. So I would mention not only the European arrest warrant, which is going to be, which is the most used instrument, still the most used instrument under the in the European Union regarding the mutual recognition of decisions. But I would mention the European Investigation Order and the EPPO as well. But this is would lead us to go really beyond the scope of this presentation. Just to be said, in the European Investigation Order, which is from 2014, the legislator recognized that the presumption of compliance of fundamental rights of the member state is not an absolute presumption, but it's relative, and it can be rebutted, which gives us the very strange conclusion to draw here, which is, if I have to be arrested, I have less guarantees than not if somebody would like to seize my house, which is weird. Which sounds weird, but it's connected, of course, with the idea that the EU law has to have a shield function as well, and not only a so-called sword function, which was maybe the function which was in the EU legislator mind when he enacted the framework decision 584 of 2002 after the 9/11. So in the European arrest warrant, we know that the rights and fundamental rights, let's call it like that. When I use fundamental rights, I would like to have both Charter Convention fundamental rights and the procedural rights, as I very briefly touched a couple of minutes ago. The question of the fundamental rights compliance of a European arrest warrant proceeding was a little bit, let's say, under scrutiny, because as the consideranda, so the whereas of the framework decision ruled, the mechanism under considerandum, also whereas 10, the mechanism of European arrest warrant is based on a high level of confidence between member states, and whereas 12 says that the framework decision respects fundamental rights. So it seemed that there could be no space for raising fundamental rights compliance issues in European arrest warrants proceedings. And it seemed that we, the criminal defense attorney, should limit ourselves to check if the boxes were checked correctly. And indeed, that was the impression that some of us had, me for sure, had in the first European arrest warrant proceedings, in which seemed to be so little space for the rights defense or fundamental rights defense. But as we all know, Article 1.3 of the framework decision rules that the framework decision shall not have the effect of modifying the obligation to respect fundamental rights and the fundamental legal principles as set out in Article 6 of the Treaty of the European Union, which is, we read it a minute ago, the fundamental rights, and not only as they are recognized in the Convention and the Charter, but even as they result from the constitutional traditions common to the member states, are general principles of the Union's law. So that's why we arrived, I put it very short, but I think that's a very common knowledge, to the landmark Aregnosi-Caldararo case of April 2016, when the Advocate General stated that there would be no space for a fundamental rights defense regarding the detention conditions. The court, the Grand Chamber, ruled that even the executing judicial authority has a space for check exactly the fundamental rights respect in the requesting state, or in the issuing state, better said. And here the most important aspect is that with respect to detention conditions in the issuing member state, the executing judicial authority must determine specifically and precisely whether there are substantial grounds to believe that the individual concerned by European arrest warrant will be exposed because of the condition for his detention to a real risk of inhuman and degrading treatment. We know that this fundamental rights assessment, as it happens to this as it happens with this idea that you need to protect fundamental rights, that it went beyond or further to the detention conditions, because we had the Elmer case, which related to the fair trial, to the chance to have a fair trial, and lastly, regarding the chance to check if the respect of the right to have of the right to health is going to be upheld in the issuing member states. So it started from detention conditions. Then the Court of Justice ruled that the fair trial shall be so the right to have a fair trial would be another ban to surrender in European arrest warrant proceeding. And now there is a 2023 ruling of April this year, which states that the executing judicial authority has to check if there is a danger to the health of the person, of the requested person, before, in case he or she is going to be surrendered in the issuing state. So as it happens from this very small case, which regarded only the cornerstone of the European Convention of Human Rights, which is prohibition of torture, degrading, or inhuman treatment, defense attorneys and courts raised questions, and now we have 3 bans of surrender or extradition, as we can say it, generally speaking, regarding the fundamental rights defense. So this is a play between the national courts and Luxembourg. Why is the here in this slide you have the link to all the procedural rules that you should have bear in mind if and once that you made it to Luxembourg. There are 3 procedures, maybe 2 of them, so the ordinary procedure and the expedited or accelerated procedure, which is called PPU as well. The difference is mainly in the time, of course, for the decision, which should amount in less than 1 year, I would say 6 to 8 months, depending on how fast the translation goes. But the translation is not to in every language of the European Union, but it's very limited, and it regards cases essentially where people are detained or their freedom is restricted. Okay, so it does not require, it does not belong to which is the court which raised the question, if it's a Supreme Court, the court of Rovereto, which is a very small city, or the Supreme Court, but it's just regarding the status of the person who is the defendant in the national case. If he or she is detained, or let me say, but it's not my aspect of my main field of practice. If, for example, if there is a minor which maybe is going to be affected by the length of the proceeding, the court is going to decide about the PPU procedure. Before the Court of Justice, there are a couple of things that I learned when I went there. So there is a written phase, the written phase, so very, to put it down in bullet points, there is the preliminary reference, which is sent by the court to from the national court. Then you will receive a letter. We are going to see an example of that from the Luxembourg court, which gives you deadlines for giving your written plea or your written arguments. How do we communicate to the Court of Justice? Through eCuria, which is a service for uploading and downloading communication from and to the court. Since it takes you a little bit of time to register and to have your credentials, I would recommend, if you have some cases in which you would like to have the question raised, to register yourself to eCuria, because it's easier than not sending a fax to Strasbourg, as we know that they would like to, even if at least under Rule 39.9 they are implementing now the chances to get to them, and they have at least the chance to upload it through a dedicated site. But with under Luxembourg rules, the eCuria is going to be more than recommended. So you will put this PDF, upload it, and you will get a receipt of what you uploaded. The written phase, bear in mind, regards not only the defendant, but the other governments and the commission. You're going to be notified when something is going to upload it, and the system works. After that, there is not oral phase, because not always a hearing is granted. It depends on the decision of the court. But if an oral hearing is granted, there is just one lawyer can appear in front of the court and speak, unless the president of the court does not give authorization for the lawyers to intervene. There is a 15 minutes time slot for case presentation, and when you will manage when you're going to the Court of Justice, the first thing will be in chambers session with just the judges and the advocate generals, and with the other counsel for commissions or representative of the governments, and the president will tell you, okay, you know how the rules are, maximum of 15 minutes, none 1 second more. So they are very strict to that. Bear in mind that while you speak, the speeches have to be translated simultaneously in all the other languages, which would suggest to ease a very easy and understandable phrasing, not too long sentences, in order to help the translators. They like if you can send them to the translator's office, because so have the outline of the text that you're going to read, and don't do like I did, which was putting down the bullet points at the morning of the Grand Chamber hearing. because when the responsible translator for that day walked up to me, and he looked at me, and I was writing what I was going to tell the court. He was very, very surprised that I did that in the very last minute. So if you send them your translation beforehand or even the same day, the confidentiality is assured. It's not going to be in the case file. They are going to destroy this the minutes, and it's just used for their better understanding. What I didn't know, but I learned very, very at the very beginning of the hearing, was that the defendant has to give this presentation as the first respondent to the court, and then there will be so the chance for all the other who is going to intervene during the hearing to explain their case or their point of view, and then there is going to be a question and answer session, which is, from my point of view, the most interesting part of the hearing, because the judges, I had the chance to have a grand chamber hearing, so with 15 judges plus the Advocate General, which in Luxembourg court is not considered a party, but he or she sits on the same level as the court. So these questions are very precise. And I don't know, in your experience, in your national cases, when we may have the impression that not every judge is knowing exactly what we are talking about, and I put it very friendly to the panel of judges, at least in Italian courts, the impression that the criminal defense attorney may have, if there is a panel of judges, only one of them studied the case file. There, every judge, or almost every judge, so 15 plus the Advocate General, they're going to give you to address question, and the question, they would like to have answers. And it happened to me to have the court interrupting the counsel or the representative of the government, which was the Italian government, at that stage, saying, okay, but I get that point, but please tell me why during the national proceeding you said that the question was not relevant, or you had this conclusion. Now here you tell us something else. So of course, they studied in very thoroughly the case file, not only at the Luxembourg stage, but even in the referral proceeding as well. Then at the hearing, the Advocate General is not giving his conclusions. Usually he reserves a couple of months or even more time to deliver his or her conclusions. There's going to be a hearing scheduled for that, but it's just for the Advocate General to allow the Advocate General to give the conclusions to the court. So a 5 minutes hearing. And then there is, I would say, months later, but the Advocate General gives the court during the main hearing, let's say like that, he gives an idea to the court, which is the deadline on which he's going to deliver his conclusions, let's say on the, I don't know, 30th of November. And so the Court of Justice will schedule a hearing for the 6th of December just to be allowed to have the conclusion in the case file. And then everybody waits for the court's decision. I put here some questions I had, and I would have loved to ask somebody before my first hearing in the Luxembourg court. So the language is the language of the national case. So in my case, it was an Italian case, of course. So the official language was Italian. and you have to speak as an attorney the language of your of the main case. So I made my pleas and answer to the question in Italian. And there is no need for special admission to the Court of Justice. So you don't have to be admitted like the International Tribunal or I don't know, in Italy, to have the right to appear before the Supreme Court or the Constitutional Court. You have to have a special qualification, but this is not a need that you have in front of the Court of Justice. And maybe there are other questions that you may have, practical questions, and please then feel free to address them at the question and answer part of this presentation. So let's take a look how this exactly happens. So we have this case, which was an European arrest warrant case in Italy. The issuing state was Croatia and Italy was the executing state. The problem here was exactly the help of the defendant. And this was the first communication we received through eCuria, which is okay. We notify you with the preliminary ruling referred to the Court of Justice. You have usually 2 months to reply for that, but it's written in the communication, so it's very plain and simple. As they explain to you, you can ask for a 10 days postponement, but they don't love it. But especially, please, in my experience, at least the Italian desk at the Court of Justice, the registrar was very, very helpful at this stage. So basically, whenever I had a question, I ringed him up and I asked him to which was the possible regulation that would apply. If you would like to have a hearing, you have to apply to that, okay? But it's not up to the defendant or the criminal defense attorney to obtain the right to a hearing, but it's be decided by the president. What I did was to ask simply and plain for an oral, so for the chance to have our requests or point of view explained not only in the written phase, but in the oral phase as well. But it has to be, usually they need a strong reason for putting in, for accepting it. In our case, the strong reason was that it was a possible ban for a European arrest warrant. So that's why I think that's why it was granted. And they referred it to the Grand Chamber as well. So you see, it was January when they notified with the preliminary reference, which has been received by the Court of Justice. And it was July when it was scheduled that in September 2022, the hearing A was being held. B, there was a Grand Chamber referral, so they told us that this was it. With this letter, there was a number of questions which the court wanted to be addressed in the oral phase. So they say, okay, we read your written conclusions, but we would like to address you specifically in the oral phase with these questions. Here again, it's just to show you, they tell you very clearly that the deadlines, that you have 15 days to notify them if you would like to appear before the Court of Justice. And as I told you, it was just usually just one defense attorney can intervene for the defendant. And they would like to know how long the oral phase will take place. Usually, as we spoke earlier, not more than 50 minutes. This is the Iguria homepage for you, just to have an idea of how that works. So you have this website in which they upload the conclusion of the Actuarial General, the decision, but even all the interventions from the other governments or from the commissions. And this is prior to the request for the oral hearing. If you may have some doubts of how that ended, I'm super proud of that, of course, because the Court of Justice in April 2023, so the hearing was scheduled for the 27th of September. It lasted all day. From 9:30, we left the court, I would say, in the mid of the afternoon. The Advocate General gave his decision within November of same year, so 2023, and the decision has been taken or communicated and published on 18 of April of 2023. So that was the experience that I had, but let's say a few more words why the Court of Justice is so important, especially in a period in which my idea, but I may be wrong, but from my side of the desk of the courts, it appears that there will not be easily better or a new roadmap or new fundamental rights or new procedural rights, because it seems very clear to me that this is the phase in which we may have to defend what we gained in the last 20 years. And if we are able to defend the principles and the rights that we were able to have so far in the next years, that would be a great result in itself. So it's not going to, I'm not waiting for the EU legislator to enact new rights, but just it's up to us to defend it. And here is the importance of the Court of Justice, because the Court of Justice does not need political consensus to strengthen rights, to give an interpretation that gives more rights to our clients and to our democracies. Let's think about the directive about interpretation and translation in criminal proceedings, the Directive 64 of 2010. We all know that the translation of the case file, the national case file, is a very sensitive issue regarding the costs that the national member states have to bear. And we all know that the directive says that only the essential acts have to be translated. What does essential act mean? So we could imagine two directions. The first one, that the EU legislator has there is a political consensus of the member states, so transferred to the EU legislator to have a better definition of what is essential and what is not essential, bearing in mind that it should be essential for guaranteeing the fairness of the proceeding, not the fact that the member states don't spend too much money. And I don't think that the member state, this is a common understanding for member states, so I don't think that the EU legislator will pick up this idea. But if we go to the European Court of Justice in questioning the fact that something that is essential from our point of view has not been translated, the Court of Justice does not care if there is political consensus or not. Then, of course, there is a binding effect of its decisions for 27 jurisdictions, which is so different from Strasbourg case law, as we all know. So we have the immediate effect to have a ruling valid for all the member states of the European Union without any further procedure to be enacted. And then, as a former judge put it, and I give him credit to that, you just have to convince 15 judges and not tens of institutions and governments. You have to convince the 15 judges, if it's grand chamber, or 3 or 5 judges, if it's a single chamber, which is a very, very, very strong point in why the Court of Justice is so important when it comes to defend or strengthen rights, which is the point of view I chose to adopt for this presentation. So what could we do? And this is my last slide. Of course, we need to get clients. No, because with no clients, no cases, no preliminary references, of course. Then study, because in my experience, of course, I said that in the beginning, and I would like to underline that. That's just the experience that I had from my very small point of view. But usually courts, they don't like to suspend the proceeding. They don't really like to have further work, saying that, yeah, we have to suspend, we have to draft the preliminary reference, we have to send it there, and I don't know, when does it come back, blah, blah, blah. So usually in the case that I presented, which was regarding the health conditions of a defendant in the European arrest warrant case, the national court, even if I asked for the preliminary reference from the very first moment on, they preferred to refer it to the Italian Constitutional Court, that then made the reference to the Luxembourg court, because they don't know how to do it. And this is, of course, the reason why I suggested earlier that the defense could draft the preliminary reference in itself. To join the international associations could be a good idea, because it gives you it gave me at least the chance to be open-minded, because when it comes to international procedures, my initial approach, and it was the wrong approach, was thinking about the fact that the national solution was the best solution ever, because I didn't know any other solution. Because we studied for decades the national criminal procedure, or the national procedures, let's put it wider. And we thought, okay, that's the only thing to handle this problem. But if you join international associations like the Fair Trials International, European Criminal Bar Association, and others, you have a double positive effect. The first one, that you recognize that the problems are the same, but solutions are very different. And you may be able to get the idea to have a comparison with a solution from another member state, which from your point of view does reflect better the interpretation of the acts enacted by European Union institutions, and you may use the foreign legislation or jurisprudence to support the interpretation that you may give to the European law in your national main case. And then the second benefit is to join these international associations is, of course, that you get somebody when it comes to cross-border proceedings. Of course, we all need that. The theory is the double defense. It's not always given that the client can pay for this double defense, but at least you will have colleagues around Europe, or Europe, if it comes only to you, international cross-border proceedings, that gives you a hint where the prosecution or the judicial authority may have not precisely explained both the legal framework and its practical applications. Ask for help. Nobody of us is able to do everything on its own. We have plenty to do with our national cases, and it shouldn't be so I did it and I do it continuously. And even some colleagues that are speaking and this we know each other because we ask each other for help. Nothing to be ashamed of. It's new procedure, and the criminal defense attorneys that made it to the Court of Justice, there are not so many, and it's a good idea to just keep track of them. And of course, I already said that it could be a good idea to draft the preliminary reference for the court on yourself. Then is there always a perfect case? No, that's not always a perfect case. It happens that you get the really perfect case, which gives you exactly the point that you would like to raise. But in order to see that exact point, you need to work through cases which are not really perfect, because this allows you to have a focus to get some sensibility, I would say, for which could be the points of view to be raised. That's, of course, always in my experience. Believe in fundamental rights and their rights, but speaking to criminal defense attorneys, we don't have to mention that. And of course, believe in your case, even if everybody is telling you that you're never going to succeed. That was not my experience, even if I had a lot of faith, and I experienced that in really recent case as well, regarding, for example, interpretation and translation issues, and the national courts, they, from my point of view, they just don't see the point of which the point in raising preliminary rulings to Luxembourg. But again, we have to insist. And it happened to us that there was a question that we wanted to be raised to the Luxembourg court in a criminalization of sea rescuers in southern part of Italy. The point there was, among else, even the compliance of of the Italian law with EU law. And in June 2023, the court in Trapani refused to make this preliminary referral to Luxembourg. And in July, 1 month later, another court in Bologna raised exactly the same point, based on exactly the same law and with the same plea that we submitted 1 month before to a court in one part of Italy. They said it was not relevant to the case. And the next month, in July, the Bologna court raised it exactly in the same terms. So at least you're going to find a court which is seeing the point. And it makes sense to spread those cases among us defense attorneys, because when it comes to preliminary references, from the importance that it has, at least from my point of view, it's not important who signed it or who had the idea, but the importance is to get this point cleared, and hopefully in the sense of a stronger protection. I think that was the presentation that I wanted to give to you. As we all know, justice requires, as it's at Martin Luther King put it many decades ago, it needs the passionate concern, the justice, I would say here, not only human progress, the passionate concern of dedicated in the individuals. And I see we are perfectly in time, so I mean, it's not going to be angry with me, because there is going to be some space for questions if you have some. Thanks a lot for allowing me to give you my point of view.